Good morning. My name is Marty Abrams, and I lead the Information Accountability Foundation. And it's our pleasure to be here at CPDP LATAM to talk about important issues in data protection and privacy. Today's panel is going to be about the balancing of employment with data protection when transferring HR data. And in this session, we're going to talk about the transfer of data out of Europe to other locations, including Latin America. And we're going to talk about whether there are any similar conditions in Latin America like we see in Europe in terms of Schrems II and worries about national security use of data. I am joined here today by three excellent speakers, old friends, people I've known for a long time. Following me will be Lynn Goldstein. Lynn Goldstein is with the IAF as a senior strategist in our council. She used to be the chief privacy officer at JP Morgan Chase and with a think tank at NYU. She is a specialist in the law, is writing on this question of HR data and transfers, and hopefully she'll share her wisdom when she does her slides. She will be followed by Jacobo Ashkenazi. Jacobo and I have known each other for about 12 years. Jacobo is with HP. He is a privacy director there, and he is the person at HP who actually has to worry about this question of whether HR data can actually be transferred. And he's going to share slides that he shares with his management team on those issues. And last but not least, we're joined by Gustavo Ortiz. And Gustavo is a barrister in Brazil. He sought me out about 8 years ago to explore my views on a number of issues related to privacy and emerging Latin American law. And since then, I've worked with Gustavo on papers and on conferences that we've done in Brazil. And he's going to be looking at this issue from a Latin American perspective, particularly with an emphasis on Brazil. We're going to present some slides. I'm the person who's in control of those slides. We know that I have limitations from a technology perspective, so hopefully this will work just fine. So if you just bear with me for a second. And we are now sharing slides. So the slide is just the title slide. So when we think about the transfers of data, we all understand that global data flows are necessary for
Marty,
commerce. Yes?
You're not sharing slides.
I'm not sharing slides?
No.
Am I sharing slides now?
Yes. Success.
Okay. Success. As I said, technical proficiency is not my high point. So the nature of data transfers are that they're necessary for commerce, but they're also critical for things such as research and other things that impact on the quality of life and therefore impact on fundamental rights. The 1980 OECD privacy guidelines came out of an organization that encourages economic growth. So the whole purpose of the OECD privacy guidelines was to assure the free flow of data by coming up with some standard concepts about what privacy means when data flows in an international basis. This question of control over data when data leaves a jurisdiction has been with us for many, many years. Originally, the concerns were about an organization's own use of the data or their commercial partners. And there was this question of whether local control of the data would cease if the data was transferred outside that original jurisdiction. So it was originally about commercial uses, and the rules were based on this question of what does it mean to maintain jurisdiction over data when the data leaves a jurisdiction. But over time, the issues have shifted to something else, and this is in the last 10 years. And they've shifted this ability of nation states to exert their will with or without appropriate fair process to acquire data from the private sector by fiat, particularly for the bulk collection of data. So it has been about national security issues, the ability of the data of European citizens or Colombian citizens or others to be seen when that data is no longer within that jurisdiction by national security agencies. And so as we think about this topic, we're going to use an agenda where we're talking about the balancing the full range of rights and interests when transferring data. That will be me. The GDPR and how it is applied is Lynn. One company's approach is Jacobo, and the law in Latin America is Gustavo. And we'll finish with Q&A. So when we think about the full range of fundamental rights, individual autonomy is one of those fundamental rights that is talked about a great deal. That is a right of me as an individual to control who sees my data and what they do with that data. However, it's not the only fundamental right that comes into play when we think about the governance of data. GDPR, which is the European Data Protection Law, recital 4 frames it best. And I'm going to quote, "The processing of personal data should be designed to serve mankind. The right to the protection of personal data is not an absolute right. It must be balanced against other fundamental rights. And that includes the fundamental right to conduct a business and the fundamental right of people to be gainfully employed." So it's not just about privacy. It's about these other rights that are impacted by the management of information. So this suggests that the approach to how we assure that the full range of fundamental rights is protected and that we give the right emphasis and balance to the particular fundamental rights that are at risk suggests one needs a risk management process where the rights to employment and conduct a business and social equity should be considered up there with the ability of individuals to control their data. And this brings up the whole question of concept of human dignity. And the fact is that that almost all human rights documents start with this concept that individuals have a right to human dignity. And human dignity is the recognition that each of us possesses special value, and that special value is divorced from anything else about us, that we as human beings, regardless of any of the other factors about us, should be treated with respect. And as I mentioned before, human dignity isn't just about our ability to control our data. Human dignity goes to this concept of the full range of rights as captured by all of these international documents. So privacy impacts human dignity, but it's not alone. Human dignity is impacted by health and welfare, which means we need to be able to flow data to assure both health and welfare and the dignity that comes from employment. So this brings up this whole question of what does risk management mean when we're thinking about data? And it begins with an identification of the key stakeholders. So those are all the stakeholders that are impacted by the use of data. It's not just the organization or the state itself as an entity or the individual that the data pertains to. It really goes to the range of interests of all of the stakeholders, including other individuals. And we see this closely in COVID-19 and the ability that every individual impacts everybody else. So when we think about this question of dignity and rights, we have to think about all of the individuals that are impacted by flows of data. This means that the severity of the risks that are identified and the likelihood that those risks will turn into negative outcomes needs to be considered. So in the concept of HR data, it isn't just about the flow of data and the risk that someone might have access. It's the impact on the individual of not being able to be treated fairly as an employee. And that means that when we think about the likelihood of something taking place, we need to measure that likelihood and balance it in terms of the fair treatment of employees against mass surveillance. And we're beginning to see these issues emerge in the discussion of Schrems II, and the absence of HR data transfers may indeed lead to unfair employee treatment, which then impacts the dignity of those individuals. So now it's time to talk about the GDPR and the law. And Lynn, that's you, and I will change your slides when you tell me to change your slides.
Great, Marty. Thank you very much. So as this old song goes, we're going to start at the beginning. And the beginning here is Schrems II, which was issued about a year ago. And in Schrems II, it was held that if a third country is not adequate, personal data can only be transferred to that third country if adequate safeguards have been made. Adequate safeguards must be capable of ensuring a level of protection essentially equivalent to that granted in the EU. But because Schrems II didn't say what adequate safeguards are, the EDPB issued proposed recommendations. Marty, please, next slide. The proposed recommendations set forth a 6-step roadmap, and that roadmap, under that roadmap, you had to determine whether supplementary measures needed to be put into place in order to, the combination of whatever your transfer mechanism is and the supplementary measures would amount to adequacy. And I'm not going to go through all the 6 steps, but under step 3, you have to assess the third country's framework governing access to personal data. And that assessment must be based on legislation that is publicly available, and it can't be based on subjective factors such as the likelihood of public authorities accessing the personal data. So you can't use a subjective test. They're talking about a purely objective test. So Marty, next slide. The EDP, and in those recommendations, the EDPB said that for 2 use cases, no effective supplementary measures could be found. And these 2 use cases, as you'll see, greatly impact the transfer of personal data. So use case 6 is the one that covers the transfer to cloud providers. And it wasn't, no effective measures could be found because cloud providers require access to data in the clear. If you got your HR data in the cloud, you need to access it in the clear. And the EDPB said they couldn't think of any effective measures, and therefore, if you're using the cloud, there's no way you can transfer your data effectively. Under use case 7, remote access is to data for business purposes, and remote access is a transfer. And there it was, they couldn't think of an effective measure because the data importer has access to the encryption key, or the data could be in the clear, either one. But again, they found that there were no effective measures. That finding has a huge impact on whether HR data can be accessed or transferred, whatever word you want to use. And so that conclusion that there are no effective measures for these 2 use cases creates issues for the transfer of HR data from the EU to third countries like the US, where the HR data usually is in the cloud or in the clear, because a lot of companies have their headquarters in the US and they have enormous operations in the EU. And so as Marty was referencing, if you can't transfer the data to the US as set forth under these proposed recommendations, then you're not going to be able to provide the same type of treatment for European employees that you would be able to, that you are providing for your US and non-European employees. Next slide, Marty. By limiting your assessment to only objective factors and not allowing consideration of subjective ones, such as the likelihood of public authorities' access to the data, but only limiting it to the objective, which is what does the law say versus how is the law applied, you're limiting what the companies or what can be done in the third country. So by making this limiting how the assessment can be done, the EDPB is preferring the right to the protection of personal data and disadvantaging the freedom to choose an occupation, as Marty was talking about, or the right to engage in work and the freedom to conduct a business. This is contrary to the EU Charter of Fundamental Rights, and companies should be able to look into the likelihood that the public authorities will be able to access HR data. So this is the situation where we were left with the proposed recommendations as they were about a year ago. Next slide, Marty. So new standard contractual clauses came out early June, and these set the stage for a change in the approach that is being taken. So under clause 14 of the new standard contractual clauses, the data exporter and the data importer must warrant that the laws and practices in the third country, including those governing the access to personal data by public authorities, don't prevent the data importer from fulfilling its obligations under the standard contractual clauses. So already the standard contractual clauses have previewed what the final version or the adopted version of the EDPB's recommendations are going to be. Next slide. In footnote 12, which is in clause 14, it's stated that in assessing whether such a warranty can be made, the data importer must look at the data exporter must look at the data importer's relevant and documented practical experience. So now we're looking at a subjective factor, looking at the data importer's relevant and documented practical experience with prior instances of requests from public authorities or the absence of requests for disclosure from public authorities over a sufficient time frame. Not only do you look at the importer's experience, but the assessment must take into account whether the data importer's practical experience is corroborated and not contradicted by publicly available information on the existence or absence of requests within the same sector and the application of the law and practice. So they're giving you the opportunity to look at what the actual experience is under the law, and you're not just looking at the actually what the law says, but how the law is applied. Next slide, please. So in the middle of June, the EDPB came out with its adopted recommendations. It has the same 6-step roadmaps, but under step 3, there are changes. And under step 3, the data exporter must assess if anything in the law and or practices in the third country impinges on the effectiveness of the SEC's, the standard contractual clauses. Marty, next slide. And if the answer to step 3 is yes, if the law is impinged, there are 3 alternatives. The first one is you can suspend the transfer. Secondly, you can implement supplementary measures to prevent the risk of application of the law or the practices of the third country. And we'll talk about this in a second, that's called problematic legislation. So it's the application to the data importer or the transferred data. Or the third one, which is, those 2 existed previously. The third one's new. You can proceed with the transfer without the implementation of supplementary measures if there's no reason to believe that the problematic legislation will be applied in practice to the transferred data and or the importer. So they define what problematic legislation is. So it's a lot of legalese. I've got it on the next slide, Marty. And it imposes on the recipient of personal data from the EU obligations and effects on the data transferred in a manner that impinges on the SEC's guaranteed of essentially equivalent level of protection. And it doesn't respect the essence of the fundamental rights and freedoms recognized by the EU Charter of Fundamental Rights, or it exceeds what is necessary or proportionate in a democratic society. So, just keeping that definition in mind, let's go to the next slide. If the answer to step 3 is yes, then the data exporter also needs to demonstrate and document the assessment that the law isn't interpreted and or applied in practice so that it covers transferred data, and the importer, taking into account the experience of other actors, not only the importer's experience, but other importers, operating within the same sector or related to similar transferred data. So this is how they allow you to take into account subjective data. We won't go through the other 3 steps. I just wanted you to have them there for completion. And so now we'll look at the changes to use cases 6 and 7 on the next slide. So in the supplementary measures, the EDPB again concluded that use cases 6 and 7, they didn't think there were effective supplementary measures that could be put into place given the current state of the technology, but they added this language: where in practice problematic legislation applies to transfers, see step 3. So what does that mean now? Under step 3, you can now go back and rely on the likelihood of public authorities' access to data. You can now do this subjective risk-based approach analysis assessment, and you can proceed with the transfer without the implementation of supplementary measures if there's no reason to believe the problematic legislation will be applied in practice to the transfer data or the importer. So next slide, Marty. These slides I'm going to go through very quickly. This is just a repeat of what I just said, but it shows you how what this approach applies to HR data. So if standard contractual clauses are the tool to transfer HR data from the EU to the third country, and if you're unsure whether the third country's law fall within the practical scope of its application, as I said, you can stop the transfer, you can adopt appropriate supplemental measures that ensure essentially equivalent level of protection, or, next slide, you can look at the publicly available information to clarify the scope of the application and practice of the third country's legislation to transfer the HR data. If the conclusion is that the legislation applies in practice to the transfer of the HR data, supplementary measures that ensure the level of protection for transferred HR data, essentially equivalent to that guaranteed in the data, must be adopted in order to transfer the data. Next slide. If the legislation doesn't apply in practice because public authorities haven't accessed the HR data, as determined by the fact that 3 things need to be considered. Importers haven't received requests for HR data from public authorities. Publicly available information reveals that data importers of the same sector as the importer haven't received requests for access to data for similarly transferred data in the past. And the publicly available information shows that it's okay to reveal the absence of requests received. Then the transfer of the HR data may proceed without any supplementary measures. So under these subjective tests, as I've just outlined it here, it is possible to transfer HR data and I think I'll pass it back to you.
To Kobo, this isn't just about data transfer to the United States. This is about data transfer from Europe to any other country that has not been deemed adequate, correct?
Yes. You want to advance to the next slide because I think that's
okay,
the first. That's the first point that I want to make. So, what I'll try to do is translate in practical terms what Lynn described. So the first thing that we started with is we needed to define what a personal data transfer is, and since looking at the documentation and the requirements, it's set out both by the European Data Protection Board and the court. We ended up with a transfer being any processing of personal data done outside the European economic area, and that means, and if I leave you with no other message on this slide, that means that this is not about data localization. This is not about where the data resides. It's not about whether you're transferring and storing it in in a country, the US or any other. It's about where can the data be accessed, meaning that if you have, in the case of HR, data operations in 100 countries, you need to look at 100 countries' laws to know whether they're either adequate, and I'll go through the steps, or what laws could provide access to the data. Then you have to look not only at what you're doing with the data, but any other actor, a processor, a sub-processor, a cloud provider, or any other company or person that's having access or storing the data. And then if that data is further processed for, let's say that you have a payroll, it's not just about your HR management, but then you have a payroll company, and that payroll company has access to the data and then process it, in a different country, then that's an onward transfer, and you need to do an assessment of that as well. So just to say it clearly, this is not just about whether I'm storing data in the US. It's about the whole custody chain of the data that you're talking about. Could you change the slide, please, Marty? So where do we start to parse this out? You first need to understand and identify all of the data importers, all of the onward transfers, as I said, and look at that map, that conceptual map of where the data is being accessed from or transferred. And then you need to go country by country and say, okay, to country X, is it in the EU? Yes, then you're okay in that country. You don't need to do anything else. Is it part of the European Economic Area? Then yes, same thing. You don't need to do anything else. If this is accessed from a third country, then you have to decide. You have to take another step, which is one of those countries, does that one of those countries that have an adequacy decision? And there aren't that many. So if that country has an adequacy decision, then you're golden. You don't need to do anything else. But if it doesn't have an adequacy decision, then you need to decide what is the transfer mechanism that you're using. Either it could be PCRs, SECs, and eventually codes of conduct or certifications, which are not available at this point for transfers, but eventually they will. So if you're not using one of the GDPR Article 46 transfer mechanisms, your answer is no, you cannot transfer the data there, because you still need a transfer mechanism. And then we come to what Ling was describing in terms of the assessing the national laws and practices. And it's not only about looking at the laws; it's looking at what the law says, but also about the practices. How does government really comply with the laws that they have set up in the books? And that is part of the most difficult part of this. But let's say that if you did the assessment of the law and the practices, and you think that there is no reason for the government authorities to access that data, then you can transfer. But if you think that under the laws they might be a reason to transfer, then you have to do a transfer impact assessment, or rather, the transfer impact assessment is this step, which then, if you decide that, as Lynn said, it's a problematic law, then you need to think about, are there any supplemental measures that I could take? And then, as we said in case 6 and 7, the European Data Protection Board said there aren't any measures that you could take. I'm not so sure that that's the case, but either if you define that the data might be accessed under the laws and practice, then you shouldn't be transferring data. And to top all of this is not a do once and you're done process for this 100 countries. You have to periodically review all the steps and assess the conditions on the technical measures and on the practices of government organizations. So I have good news and bad news for those of you who practice privacy management and privacy law. You are not going to be out of a job. This is going to be a continuous process, and job security is guaranteed. Can you Go to the next slide, Marty, please. So in a way, I wanted to touch upon what are the organizational and technical measures, the supplemental measures. So in order to know that, you need to create a description of the data transfers, all of the data flows, the type of data that you're transferring, who are the data subjects. You need to document all that and document what data is being transferred and who has access to it. Then you have to create this transfer impact assessment that Lynn was referring to in a way, which is looking at the laws and analyzing the protections and understanding applicable laws and practices. And then you have to document a description of technical and organizational measures that you're applying, if possible. The other element that you have to do is you need to maintain statistics about requests you've gotten, which is something that will require you to put in place a government access to data process and deploy it in every country so you can get statistics, because a regulator could come on to you and say, I need to know if you've gotten any requests or how many requests you've gotten and what is the type of request that you've gotten. Is it a law enforcement or a national security one? So this is a process that we are going, it's not part of this assessment, but it's a process you're going to have to implement as well. You want to go to the next slide? As I'm going to skip the slide because Lynn already covered what the laws and regulations are, and I kind of touched upon that. But what I wanted to show you is a preliminary, very preliminary analysis of how this should look in terms of the US. So we talk in general in the US about 4 laws. One is Section 702 of the Foreign Intelligence Surveillance Act, also known as FISA. And the relevant piece here, at least for my company, is that it applies to persons outside the United States, but also to electronic communications or service providers. HP is not under the definition of US SEC 1881b4 a electronic communication service provider. So in a way, we are not subject to FISA 702. So check there, HP does not meet the definition, and therefore it's not applicable to us. The next one would be Executive Order 12333. And again, this is in general a directive assigning to US intelligence agencies the ability to tap into and disclose data. It's not applicable to HP. We have put in place organizational measures to comply with the effective level of protection. This means that our data is encrypted in transit, and therefore, even if it tapped, it does not. We have a measure in place that could protect the data. Therefore, check. We could under this transfer. You want to go to the next slide? Again, the Directive 28, Presidential Policy Directive 28, is about signals intelligence, is about tapping into communications. And again, it's not applicable to HP, and therefore we do not consider this impactful in this context. And the final one is the Patriot Act. So the Patriot Act gives the U.S. government and law enforcement agencies enhanced powers to request access to the information of non-U.S. citizens for foreign intelligence and to prevent terrorism. As a U.S. company, HP is subject to the Patriot Act, yes, so we couldn't say this doesn't apply to us. And while we cannot guarantee that it will not be used in the future, our experience is we haven't received any request of this nature, and in any case, the risk of this data being relevant in that context is really low. We've also not heard of any other companies who have publicly said or organizations that have said that they have received requests for HR type data under the Patriot Act. So I have it as a yellow because for now, and until this situation changes, we consider that the impact might be low, and therefore the possibility of us being tapped into providing this data is extremely low. And therefore, we consider that even though there are no measures that we could put in place to prevent this, the transfer can go ahead. So in a nutshell, this is the TIA. You still have to have all the other elements that I described before, but this is how it would look. Now, this is one country. I still have 99 more to go in terms of access. I would leave it here, and I'm happy to answer questions once we've done with the presentation part. Gustavo, I think it's your turn.
Yeah, that's me. Oh, thank you, Jacobo. Well, maybe my presentation will make you get to 98 countries in your list, because what I decided to do is to, well, I'll show you that you won't get to 98, maybe you get to 98 and a half, because what I'm going to show is an incomplete request for a transfer impact assessment in practice, right? Answering for Brazil as a data importer, if our legal system is problematic, or in fact, maybe this problematic wording is not appropriate in the sense that it's very, as Lynn said, very legalese and very specific what is problematic, but we could use the word adequate here for this purpose, right? So basically what the first two slides is what I've been asked by clients in Europe that are data exporters, how would Brazilian law will bear adequacy already under the EDPB recommendations, right? And these are the questions that are made to us, right? The first is, are there Brazilian laws or regulations that allow public authorities unrestricted access to importers' personal data, or conversely, only to data processed in Brazil or collected here? And the first part of the question makes this distinction, right? If data, it must be imported or if it's collected here, if there's a difference there. And I believe that we're going to address this in question and answers. Alisa, so that Marty is wishing to address this matter of the localization of the data, right? And they ask, based on which law, right? And as with the US example, there are a list of laws in Brazil that might give access to public authorities on data, right? For what purposes? What data they would have access to, right? And the possibility that the importer will not provide such data to competent authority or limited access. And in this question D, there's the issue of encryption, right? If encryption keys should be left in the exporter country or not, right? Marty, you can go ahead. And the second question is the question that is general, right? It's a general adequacy question, which is very broad in my view. If from a legal point of view, the power is given to public authorities in Brazil to access the transfer data exceed what is considered proportional and necessary in a democratic country. That is, could it violate Articles 47 and 52 of the European Charter of Fundamental Rights, which is, in my view, a very broad question in practice. And yes, we would say that Brazil, my immediate answer to this is that Brazil constitutionally is a democratic country and protects data in a proportional and necessary fashion and would be adequate. But this is very, it's a broad question, as I said. Marty, you can go ahead. And then I piggybacked a little bit in what Jacobo had issued in terms of what is a transfer impact assessment to discuss if the questions that are being made will be enough, at least the questions that the requests that are being receiving are enough to comply with the EDPB recommendations, right? And if you get the list that Jacobo prepared, first, the privacy principles and authority, that's that's something that is part of what is being requested here. The legal analysis, which is sufficient. And then there's the matter of actual practices and statistics. Obviously, are being requested in a legal fashion. But I don't know if the Brazilian importer is looking at these actual practices. At least we haven't been asked that. So especially considering the new recommendations that are less subjective and more less objective and more subjective, right? Which establish that besides practical experience, which needs to be duly justified, organizations should take into account relevant, objective, reliable, verifiable, and publicly available or otherwise accessible information that reveals whether the transfer data will be appropriately safeguarded in practice, right? I don't think that's something that a European institution would know in Brazil, right, regarding Brazil. So I think that as Jacobo said, the requirements are very high, and the questions that are being made, at my view, at this point, are low, or at least don't encompass all that the recommendations are asking, right? Sources that may be used when conducting this analysis include reports from regulators, parliamentary and independent oversight bodies, reports from providers of business intelligence, as well as from business, professional, and trade associations. So if you want to be subjective, you need to look at these matters, right? And this is very cumbersome, and I didn't see this happening, at least in the requests that are being made to us. Mari, you can go ahead. So, as a general rule in Brazil, right, public authorities to personal information held by private entities is not unrestricted, right? Every law that establishes the access to data, to personal data, in any sense, establish a rule, and you can have, the public authority can have access through administrative requirements, or requirements by the authority by itself, right, or through court order, right? Those are the two ways in which you have this in Brazil, right? And except the ones that are requested by administrative order are generally they are restricted to registration data, usually name, marital status, nationality, parents' name and address, and these generally can be requested by the police chief when there is a police inquiry open, and by the public prosecutor while in the exercise of prosecutorial activity. And these are a couple, or well, not many laws that allow these. They're related to criminal persecution, right? And Brazil makes no distinction between data collected by a company in Brazil or imported data. Marty, you may go ahead. In terms of adequacy, obviously, except for the matter of lacking an independent DPA, we always need to remind that ANPD is not yet an independent DPA. They're requesting that, and OCDE has made a point that it would wish that our DPA would be independent. There are no major concerns in Brazil regarding systematic adequacy, right? So we're consistent with the GDPR in regards to applicability of principles, right? And matters, and one thing that is special about our law, the matters of public safety, national defense, state security, or investigation, prosecuted criminal offenses, in terms of data protection, they will be dealt with a specific law that is there's already a project. It's led by my friend Danilo Doneda and by Laura Schertzel-Mendes. There's a board that is discussing this project in Congress, right? So these matters, we still don't have a law that regulate data protection within prosecution, national defense, state security, and investigation. Marty, you can go ahead. And these are the main laws that we have that do, in a sense, either permit administrative requirement by authorities, or secrecy might be broken by a court order, right? And the first is the one that protects telephone communication, and it's the Lei do Sigilo Telefônico, and that's one where the rule is secrecy, and you may break it by court order for some reason. And then there's Supplemental Law 105, which is regarding to tax and banking information. The Brazilian Penal Code has provisions in this respect. Law 128050 from 2013, which was the one that leads with organized criminal activity, also has this type of requirement. Laws relating to money laundering. There's the statute of the police chief, which establishes administrative powers for the police chief to ask for information in criminal prosecutions, and also our law regarding the Internet Civil Milestone. All of these laws either permit administrative requests, or court rulings establishes that data must be requested to public authorities. You may go on, Marty. So the question is our legal system problematic or adequate, right? It does not seem to be the case. We seem to be adequate. However, Marty, you can go on. We have some special things that surprises arise from time to time, and this is excerpt from a draft resolution by the National Council of Public Ministry in Brazil, the Public Prosecution in Brazil, intended to regulate the LGPD. And the first comment is that they shouldn't regulate the LGPD because there's going to be a special law regarding criminal prosecution. So that law has to be regulated if they wanted to do that, right? And you go to Article 17, and this is only a proposal of a draft resolution. And it says that the Brazilian Public Ministry, in defense of undisposable individual, collective, and diffuse fundamental rights, and in development of cautionary action in the context of state prosecution, and within the scope of due legal process, will have unconditional access, and that's very clear, to personal databases of public nature, or those relating to services of public relevance, as well as to private databases being able, for those purposes, to exercise its power of requisition. So saying that it will have administrative powers of unconditional access to any kind of databases. So obviously that wouldn't be adequate. We would have a problematic or inadequate system if this draft came to being. So Marty asked me when he was preparing this presentation, this session, if lawyers or companies in Brazil should be, in Brazil, no, but in Latin America as a whole, should be worried with this, the recommendations, and if they should be worried with if our laws are adequate. And I would say that that is the case. Our system is generally adequate, but you always have exceptions or situations in which you will be not following some of those recommendations that Lynn and Jacobo have stated so well, right? Going now to export requirements. Laws in Latin America in general, they follow the same reasoning as the GDPR, right? And I got a list of 6 countries. I went for the GDP as a criteria, right? And Marty, I'll leave them for people to read afterwards, but there's a table that is more comfortable. If you follow, you can move to the next slide. And we prepared the table, right? So the rule here for Mexico, Colombia, Argentina, Ecuador, Peru, and Chile for export requirements is that transfer countries should have a suitability level, adequacy, or consent is also the rule. And then you have their variations regarding international treaties as reasons that would allow export, right? Principle of reciprocity, cooperation agreements, right? And these are covered for Mexico, Colombia, Argentina, and Chile. Exchange of medical and health data, and that's for Mexico, Colombia, Argentina, and Chile also. Public interest safeguards, Mexico and Colombia are the only ones that state that. International collaboration, cooperation against terrorism, drug trafficking, human trafficking, corruption, among others. This is restricted to Argentina, Ecuador, Peru, and Chile. And exercise of defense of rights and the process or due process in Mexico and Colombia. And these are the export requirements. We don't have, as I said, we don't have a Max Schrems in Latin America, neither a Jose Schrems or someone of the like. So we don't have EDPB regulations, right? We might have regulations, specific regulations by DPAs. In Brazil, we don't have that. In Brazil, we won't have that for the next 2 years because there's the agenda in Brazil for regulatory agenda, and it doesn't cover international transfer yet. So for 2 years, we're only going to have the wording of our law. We won't have regulations or recommendations by our DPA. I don't know exactly how this is in Latin America, but I don't believe that we have restrictions that are as cumbersome as those enacted or recommended by the EDPB.
So that was fantastic, guys. I did not read a disclaimer that I'm required to read, and I will now read that disclaimer so that the folks who are organizing this session will feel secure. The comments made by Fundação Getúlio Vargas employees and guests during online events and broadcasts exclusively represent their opinions and not necessarily FGV's institutional position. We also reiterate that everyone present here has agreed to participate in this event spontaneously, and with this, authorize the use of their name, voice, and image in addition to see the property copyright scans related to their exposure for this transmission to be made available later on VGV's official channels. To continue with this transmission, we ask that you express yourself by saying yes, indeed. So I personally agree to these conditions. Lynn, you're muted, so you have to unmute to agree.
Yes, I agree.
Jacobo, do you agree?
Yes.
Okay, and Gustavo, how about you?
As you, I agree.
Okay, thank you very much. And so I'm going to, ask some questions. Hopefully, if we can see questions from others, we'll let others ask questions. But there are only 2 countries in Latin America that are deemed adequate by the European Union. Gustavo, you've discussed the situation in Brazil, and the situation in Brazil is that that you've looked at the law and you're now increasingly thinking about the practice, and you're thinking about future law. But in terms of this question of subjective tests, can one speak about Latin America as a whole, or is this the type of assessments that Jacobo spoke about? Is that going to actually be necessary for lawyers in Latin America who are advising their European clients, or even their own companies that have employees in Europe? Are they going to each have to do these assessments?
Oh, I think they have to be individual assessments. The nature of the recommendations, in my view, will require that. Simply answering such requests as we are doing, it's very technical in the sense of to establish whether you're adequate or not, and when they say now that it's more objective, I feel that it's always subjective in a way, this matter of adequacy. For instance, I didn't mention another case here in Brazil that our FBI is intending to establish a database with 200 million biometric data, and this is creating also an issue. But this is also recent, together with that one of the National Council for the Public Ministry in Brazil. So what I'm trying to say is that I believe, and from what I know of Latin America, I believe that there are different flavors and there are going to be different, despite the fact that the general adequacy program is the same, right? The general rule is the same, and very much, I don't know if all of them are inspired in the GDPR the way that Brazil is, very much so. When you get to the specifics of the legislation and what police authorities and what national defense is and what all these requirements are, they'll be very much different in each country, and they will change, and they might change regarding the political atmosphere that you have in the country. For instance, this ruling or this proposed regulation for the from the public ministry in Brazil is drafted by a military in Brazil, right? And we know that we are under a government that is has military power is strong, right? So I think it has to be individual, and I think that you're very fortunate, Maury and Lynn and Jacobo, to be discussing the matter of HR data, because there should be a specific, like a fast track or something for this kind of data, in the sense that if it's the bulk, and it might be the bulk of personal data transfer in the world, right? And it's so important, and it's usually not going to be required by the authorities. That's my feeling, that if you get the requirements, the administrative requirements in Brazil, and I might be mistaken on that, but they come from telephone companies too. They're directed to telephone companies, to credit card operators, internet service providers, mostly, right? And they're administrative. So this is the bulk of the material, and they're only registration data. And I don't feel that, for instance, the matters of HR data, we will need to, I know that Jacobo wants to keep his job, but I'm sure that he doesn't want to keep his job in that way, like these. He won't have fun in investigating these 99 countries, and I think he won't have fun investigating Latin America as a whole, individually, country by country.
So, Kobo, are you having fun?
Yeah. So far, it's becoming interesting. But more to the point that I was making is that the transfer impact assessment or the legal analysis is probably the minor part of this. The major part of this is collecting all of the information that you require to do the assessment, understanding who has access to data, what sub-processors you're using, and other work that has to be done to describe the transfers and the type of data that there is. There's a lot of other work that is not the legal work. There's a lot of other work that needs to happen. So in terms of, for instance, providing HR is a very straightforward proposition, and we chose this one as a simple one. But imagine when you're providing services to another company, then you have to look at what data is the controller providing to you, what data subjects are part of that, who's accessing the data, how is it transferred, what mechanisms are in place to protect the data. Just documenting all that is going to take the bulk of the work. The legal work is a small part compared to that.
So, Lynn, you're leading a project at the IAF specific to HR data. That's one of the reasons we picked this topic as the topic. What do you think in terms of, you can make the subjective decision that it is highly unlikely that HR data will be an interesting target for bulk collection, but that subjective decision has to be based on objective measures. And what type of objective measures, in terms of, we've checked with others and it's not going to happen, and then we can talk about whether that applies to other types of data. But what have you found?
Yeah, so one of the things that, as Marty mentioned, we're doing a study We interviewed several companies about their experiences. And you, as I mentioned earlier in the presentation, you can look at what the actors' experiences are. So that's one of the things we did is we talked to several companies and we asked them what their experiences were. And the U.S. law is that national security letters are accompanied by non-disclosure agreements. But if you don't get a national security letter, there is no non-disclosure agreement. So you're perfectly able under U.S. law to disclose what your experience is about not receiving any orders. And so companies who haven't received these orders have been, quite willing to discuss what their experiences have been regarding HR data. And as Marty mentioned, we chose HR data particularly because of the dilemma presented under the proposed recommendations raised by use cases 6 and 7. So those companies talked about their experience. But as the adopted recommendations point out, individual companies' experiences aren't enough. And so fortunately, in the US at least, the Departments of Commerce, State, and the Director of National Intelligence put out a white paper. And they talked about, because you can read the definition of electronic communication service provider, which Jacobo mentioned, under US law, which governs whether FISA 702 and some of the other surveillance laws apply or not. And that definition is very broad. So as I mentioned, Commerce, State, and DNI put out a white paper, and they talked about what the practical application is of these surveillance laws in the United States. And they said that if you're an ordinary commercial business, a company that provides ordinary commercial products or services, and you are dealing with ordinary commercial information like employee, customer, or sales records, you have no reason to believe that U.S. intelligence agencies would seek to collect this data. So my view is that that's the type of corroborating source information that the adopted recommendations are talking about. You can't just look at what your importer experience has been over a period of time. You need to look at what the experience in the sector is, which we hope by looking at other companies, we've demonstrated what the experience in, if you call HR a sector, we've demonstrated what other HR, what the experience is with respect to other HR data. But the other point is that we have expressions of views from the U.S. intelligence agency, the departments that would amount to the U.S. intelligence agencies in total, about what their intentions are with respect to the collection of this type of data. And so in total, that encompasses the type of assessment that you need to do and the type of data that you need to collect. So that's the experience that we've had, Marty.
Well, thank you. Jacobo, in terms of the questions related to the U.S. as an importer, have you seen the same concern in Europe about other locations as the locations where that data might go? Have there been, we haven't seen Schrems take on the question of data flowing to the Philippines or to which is a big processing location, or India is a big processing location. Is that an issue that has been raised in your discussions with European officials?
Not officially, but there is the actual line is you should do an assessment to all countries wherever the data is being accessed or transferred to. So the U.S. was clearly signaled in the case raised by Max Schrems, but it's likely that you're going to have to do this assessment, as I said, for all of the other countries. And there are countries where we know there are surveillance programs because of the Snowden revelations, but also because we can assume that there are other countries in Asia or in Europe even where who are not part of the European Economic Area where those activities take place.
So, Gustavo, when I was discussing this session with the conference organizers, one of the things they were concerned about was whether Latin American data would be considered safe in the United States. So, the United States is probably still the major location for cloud computing. It's a major economy. In terms of the questions you're getting from your Brazilian clients, are they concerned about the flow of data to the United States, particularly HR data? Is this something that concerns them, or is this at this point something that's only being thought about in the circles of those who really focus on the details of data protection?
I think clients, as a general rule, what the concern that clients have at this moment is the fact that we don't have rules for international transfer, right? The only rules that we have are the rules of the law that is a very broad, well, not broad wording, but it's the template, let's put it that way, wording for international transfer. And so this is I would say that this is a blank in regulatory effort, right? And there has been a lot of not protests, but people were clients and the privacy community in Brazil were surprised by the fact that our regulatory agenda did not provide for regulation international data transfers for the next 2 years. So, and the agenda for 2021 and 2022, we don't have this coming up. So it's a little bit of uncertainty that is the question. Will I be adequate if the way that I do data transfer in Brazil? And what's happening is that everybody is looking for their own BCRs and seeing the standard contractor clauses that they have in Europe to apply that in Brazil. Regarding the question of protection, I think it's more of a general concern, right? Or a concern that is, as you said, there's a shift for the concerns regarding data transfer, data flows in the last 10 years. And what I have to say is that it's a question of sovereignty, right? And we will have to have concerns with every country depending on the situation. For instance, if you didn't have the NSA whistleblower 10 years ago, maybe there wouldn't be much of a concern regarding the U.S. And it was it was a concern specific to an age regarding the manners of terrorism that happened in the U.S. So I think this shifts a lot, and every country will have its particular problem or issue on this matter. I wouldn't pinpoint a country. I would say that it's historical, and it has to do with context. And probably what I think is going to happen is that Brazil is going to follow, tends to follow. I'm guessing here, but tends to follow the European view in this regard.
So there was a paper, pretty much a book that was issued a few years ago with Jim Dempsey who's a professor at University of California, Berkeley, as the lead scholar on it, with academics in 22 countries looking at this question of national security requests for data from the private sector. And in all 22 countries, whether there was specific laws that were visibly allowing for that, the fact is national security processes tend to have, when they believe their populations are at risk, tend to make those requests for data that they believe will help them to keep those things from occurring. And that was the case in all 22 countries. And that study included Argentina as one of those countries that was looked at. So, while this is most visibly a U.S. issue, it's not purely a U.S. issue. The European Parliament, the Libe Committee of the European Parliament, issued a report just this week. That's a research report and on exchange of personal data after the Schrems II judgment. And in that report, one of the recommendations they make is that there be an agreement among a whole group of countries, including all of the European community countries, plus the Five Eyes, which includes the United States, Australia, New Zealand, Canada, the United Kingdom, and I believe Japan is looking to join the Five Eyes, so that this data collected in one location for national security can be shared with others. Jacobo, is this something that you at HP can solve? Can you as a company just say, we'll require the government to act accountably when they have the data?
No, it's not something that either HP or any other company can have an impact on. At the end of the day, it's a government to government question, and the only path forward that I can foresee is to have an international agreement on what constitutes, adequate or proportionate government access. I was very hopeful that something would come out of the OECD process. It seems that that's going to be stalled for a little while. But until governments sit down and have that discussion, we're going to have to jump through all of these hoops.
And in terms of the OECD process, we're talking about 42 countries that are members of the OECD. That process at the OECD was being pushed first and foremost by Japan. In some ways, it's not surprising that this process is not going fast. Whenever you have that many governments involved in the discussion, it is very hard to it's very hard to make that progress. And the question is, where is that pressure going to come from? The IAF in a paper that we did based on a project in 2014 suggested there could be accountability principles as it relates to government use of private sector data. And I think that's still something that it needs to take place. So, Lynn, do you think that we're going to see consortiums of companies looking to have a similar type of data that Netflix generated in the United States from other major locations where data is processed?
Yes, I think that probably makes sense. One of the things I wanted to mention, and I forgot, is that the IAF has put out a paper on its website that after the proposed recommendations from the EDPB came out, and we were concerned about the impact of use cases 6 and 7 on HR data. We wrote a paper saying that subjective information needed to be taken into account, that considered how the government's failure to access public authorities' failure to access HR data needed to be taken into account. Now that the final recommendations have been adopted and the new SECs have been issued, we're updating that paper. And so a lot of the things that we've talked about here today will be between the paper that we wrote originally and the updated paper, which is coming out soon. Will both be on the website, so you'll be able to find all of this information there. So, but I do think consortiums will. I think that's about the only way to deal with these kinds of issues. Otherwise, as Jacobo has talked about, you have to analyze all this. Both Gustavo and Jacobo have so eloquently illustrated here today. You have to do these analyses yourself. And I do know for even before the idea that you needed to do a transfer impact assessment to assess the adequacy of countries. Companies were talking about getting together and sharing the adequacy assessments that needed to be done, and then sharing them amongst each other so that they could cut down on the cost of doing some of these adequacy assessments. So I do think these kinds of things will come about to the extent that companies feel like they are in similar sectors or industries and can share that kind of work and cut down on the cost and expense and time to do all of that.
So I just want to mention that if someone wants a copy of the presentation that we did this morning, just send an email to mabrams@informationaccountability.org, and I will send you a copy of the presentation. Again, that's mabrams@informationaccountability.org. We've not had any questions from the audience, and I'm going to ask each of the speakers to just do a summary, or just not to do their final point in terms of whether they think this ability to do subjective judgments on the likelihood and impact of data and compare it together against other interests that are in play in terms of the free movement of data, be it research, be it HR, be it scientific discovery, be it just the creation of better products. Let's lead with Jacobo on that. What are your final thoughts? And your blog, and you have to unmute yourself.
I have
Jacobo.
to unmute myself. Yes. Thanks, Marty. I think that we're going to have to spend some time looking at the experiences. We all get law enforcement requests, but they're probably localized. I haven't come across a law enforcement request about overseas data for a particular country. We do get requests from local law enforcement about local access to, does this person really live where you're billing the service, right? That happens, but it's not often that I will get, or to my knowledge, we've never gotten that type of information for HR, other than maybe in child custody or child support cases for HR, but that's very local. It's not something that will happen on a U.S. basis for a European data subject. And I think that this is something that usually we didn't keep track of in a systematic way in the past, and that's as I said, putting together a government access to information process is one of the first steps that we're going to have to take, and we're already taking. And so to get information and to be able to inform, our experience on this matter, and I guess that's going to be the new normal. and we're going to have to understand that for every type of data that we have and we collect. And data minimization becomes even more important because you can't provide what you don't have.
So if you find, and I'm just asking, and please feel free to say, I have no clue. If you find that that once you start tracking that there are numbers that it's not one or two, it's more than one or two, do you then have to have a process to determine whether these requests are necessary for whatever it is that the police force is trying to achieve, and proportional to the interest of others? You're going to have to do that analysis.
Yes, that has been baked into our government requests process.
And just going to ask you, because we have the time, and was that something that this process that you could develop in 15 minutes, or did it take multiple people and lots of discussion before you came up with the process?
The latter, and it's still it's not just putting it on paper, it's how do you operationalize it. So you have to build the tools, because it's not something that you can do on a pen and paper. So we are in the process of building and putting out those tools, and then there's a process of training, right, the people, because it could be that you get a subpoena from law enforcement driven into one of your offices, and it's taken by the person at the reception desk. Well, you have to train that person, and how do you deal with that, and how to channel it to the appropriate legal department in that country, and then what does the legal representative do, and how do we communicate. So there's a lot of process building and tools building that has to go into that. So it's not something that you're going to have ready at your fingertips in 5 minutes.
So Gustavo, does this give you ideas of products you need to develop for your clients?
Well, patience is one of them, but the thing is, my feeling on that is that police and law enforcement has their usual suspects, and they do have the usual suspects regarding the information they need, and I don't see the recommendations focusing on that in the practical matters of what is usually needed. It's a broad issue on is it the same, is it adequate, but it's not looking. I think that the way they have to look at it is to look at what are the general fluxes, actual fluxes of data regarding that. And I might be wrong here. It's just an impression of someone that has read the recommendations, that understands what is requested in Brazil as a general rule, and sees that we're going to be implementing controls over data that is not a usual suspect regarding law enforcement teeth. Right, regarding their and it's also not only data but companies, right? There are companies that are more the requirements regarding to contribute with law enforcement is much more necessary than or used than other companies. For instance, here in Brazil, there's a famous case of Google's president being in Brazil being incarcerated because of non-compliance, right? And you don't have a rule for non-complying with this administrative order, right? But this happened in Brazil. So we have to look at that also when we look, because the way that I see it, it's a general recommendation, and Lynn might correct me here, it's a general recommendation for every company, right? But you do have the usual suspects in law enforcement, and I think that should be factored in on this type of discussion.
So, Lynn, you've got 2 minutes to tell me, what does this mean for your smaller clients, the clients that you've developed GDPR Simple for is do you have to do a module on national security requests?
No, what I did, so, there's only so much you can do for smaller clients, but we're gonna take the scenario that probably covers the most likely, which is you're a U.S. company, you're a company that's importing data to the U.S., and we're gonna assume that the U.S. is inadequate, and we're gonna we're gonna have a transfer impact assessment that, goes through the drill that I just described it for you, but for, not just for HR data, but for all kinds of data, and ask the questions that you have to ask. And hopefully if you're a small company, you're most likely, small or medium-sized company, you're most likely not an electronic communication service provider. And therefore, you're going to hopefully get yourself to the conclusion that you don't have to provide supplementary measures. But ask all those questions. And if you do get to that conclusion, then it gives you the alternatives about what supplementary measures you need to provide. But there's a transfer impact assessment module that you need to document generator that you need to go through, and it tells you exactly what to do. And again, I'm going to answer the question that Gustavo just raised, which is, the EDPB recommendations are just recommendations, but the standard contractual clauses have the same requirements in them in clause 12 and footnote, or clause whatever it was and footnote whatever it was, and that's a legal requirement. So they're spelled out more in the recommendations, but in footnote whatever it was that's in the slides, that's the requirement. So
the fact is, and I'm going to first of all thank you all for taking the time to really prepare for this session. Thank you to the audience that listened to a session that had tons and tons of detail in it. But what this really does raise the question of is how do all of the stakeholders in data protection think about the balancing of the multiple interests that are in play? There are times where national security and law enforcement is incredibly important in terms of protecting our interest in life and freedom, and freedom from crimes like fraud. And the fact is, there needs to be this ability to find a trustworthy means for balancing of interests. And that's what we're really talking about here at the end of the day. Thank you so much, and thank you for joining this session.